we just want to take you through the timeline of this very important story that my colleague Ayanda had even indicated is arguably the biggest story today, because the most important one is whether the work of the impeachment committee will possibly be halted by this judgment. Now, just to remind you of the facts around this case, in 2020, we had the cash being stolen. This was at the farm of the president. And then we also had in 2022, now Arthur Fraser opens a criminal case against the president and a number of officials for the concealment of this crime. And then we move to beyond the burglary. This is in August of 2022. Now, in August of 2022, Ramaphosa faces pressure in Parliament for this matter now, and then there was going to be an inquiry that was to be set up, this, of course, being the Section 89 inquiry. As you can see there, those are, in fact, the visuals of my colleague, Oliver Dickson, who is outside Parliament in the Western Cape. And, Oliver, a very good morning to you, a very important judgment today, quite consequential, if you will, given that it has the likelihood of stopping the work of the impeachment committee. They have continuously stated that they believe they're on the right side of the law, given that the Court had gone on to order that they continue their work. But here we are at a lower court, if you will. This is a high court, the apex court having given them that go-ahead to continue with their work of the impeachment proceedings. But here we are today. Just talk us through everything pertaining to this case and just its significance.
Yeah, the Constitutional Court was quite clear that the Parliament has to go ahead with the impeachment work until and unless a court sets the Section 89 panel report aside. The Constitutional Court had dismissed President Cyril Ramaphosa's earlier attempt at getting the report set aside. He had directly sought relief from the Constitutional Court on that. And then when the report became live again, he then took it to the High Court. That case is to be heard early in September. Now, that date is important because that was part of the contention in court. The president, on the balance of convenience, which is one of the arguments he has to make to meet the threshold of an interim interdict at least, was that there wouldn't be too great an inconvenience that would be bestowed upon Parliament and the impeachment committee should this interim relief or interim interdict be granted. The reason for that, the president argues, is that the extension or at least the suspension that they seek will only delay the committee's work by a month and some change. That is to say, up until the review court hears the substantive review application in early September, and given in that case is also on an urgent basis that a judgment will be handed down pretty soon after it's being heard in September, and once the review court has made a decision, then Parliament can either go ahead with its work should Parliament win, or at least should the committee win on the substantive review, or the committee's work comes to a complete end should the president win on the substantive review part of that case. Now, the arguments that were made here last week in court were fourfold. The president had to meet the threshold on 4 counts. One, he had to argue that he would suffer irreparable harm. Secondly, he had to argue that there was no alternative remedy available for him. He also had to make an argument on the balance of convenience. That is to say that either he will be inconvenienced in a way that is prejudiced, or that Parliament would not be inconvenienced. And lastly and importantly, given that this was an urgent interim application, he had to also make an argument pertaining to urgency. Now, the president, of course, through all 4 of those, received quite a bit of pushback, and particularly on the argument around irreparable harm and the prima facie right. The respondents in the matter, the ATM as well as the EFF, made the arguments that the president has no prima facie right to interim relief, and the president has no prima facie right for a impeachment hearing to not be held against him. On the argument pertaining to irreparable harm, the president made a fascinating argument, a twofold fascinating argument. The president's team, through Wim Trentgrove Senior Counsel, made the argument that the president might potentially be embarrassed by members of Parliament, and that embarrassment is one that will not just deface him, but would also to face the country. Importantly, to that argument, the President submitted that given that he would have no recourse against defamatory claims made against him in Parliament, given that members of Parliament have parliamentary privilege protection. That is to say, everything and anything they say in Parliament cannot be held against them in a court of law. That's effectively what parliamentary privilege is. Therefore, the President wouldn't be able to sue anyone who makes the defamatory claims against him or who makes really disparaging claims against the President. And that was an important part of the argument. The President also argued on irreparable harm, that this would take valuable time away from him from running the country, given that he would now have to focus all his attention on these impeachment proceedings. The response that we heard out of court that we heard in deliberations in court between opposing counsel was that, well, if that's the case, then no president would ever face an impeachment hearing, and that would render the instrument blunt, given that every president could simply say, I'm too busy to attend to these things and the country needs my attention more. And so the opposing counsel there, of course, representing the ATM, made the argument that it's just not good enough an argument. Now, of course, that is yet to be decided upon by the court, which will hand down its judgment at 10 a.m. this morning. Lots more at play there. Of course, the President made an argument that, which obviously will only be adjudicated in the substantive review. The President made an argument there that the panel, the Ngcobo panel, had misdirected itself in its evaluation of evidence versus information. Right? Very importantly is the argument that's being made around what that means for the mandate of the Ngcobo panel that's set. The response we heard there from opposing counsel was that, well, they only had 30 days to compile this report, so they had very limited time. But more than that, they had no powers. They couldn't subpoena anyone, or they couldn't ask for evidence to be submitted beyond what they were able to get in the public domain and from those who volunteered information. And lastly, they had no forensics capabilities to be able to scrutinize and test the evidence rigorously that was submitted before them. And that limitation is one that the court will have to consider.
Indeed. And when you say there's a lot at play here, Oliver, there are also political implications, and as much as we're awaiting that court judgment, it does have political implications. What we also saw play out was when the decision had to be taken around the Speaker of Parliament's view on this legal action, because the Speaker or the National Assembly itself opted to file a notice to abide by whatever judgment. I mean, that garnered quite a lot of criticism, both inside Parliament with the other political parties, but also outside.
Yeah, no, certainly. And of course, the backlash that the Speaker received there was largely from parties that are represented, which is all the parties really, represented in the 31-member impeachment panel. So much so that the chairperson of that impeachment committee had then intervened and opposed the application that was brought by the President. Now, the explanation by the Speaker was simply to say, whatever the court rules, we will abide by. But what the Speaker did provide the court with was sort of, the sort of application you would often see from an amicus to say, we will assist the court by providing information around what the impact and implication of either decision might be on the work of Parliament. And the Speaker believes, at least to the extent that she expressed this through media engagements, that she plays an impartial role in this, and therefore wouldn't be befitting to then oppose or, support an application or an opposition to it.
Which is quite an interesting perspective, because there was the view held that Section 89 report essentially belongs to Parliament. They set out to establish that three-member panel, but then beyond their work, they were functus officio as the three-member panel, and that report is that of Parliament. And essentially the argument was that she would have to defend a report that essentially belonged to them.